Hi, hi, good afternoon. Welcome to everybody who's coming in. We're going to wait a few seconds just for our webinar room to fill up before we begin. But thank you. Thank you for making the time to be here for this really important conversation. All right, I'm happy to go into the introduction. I want to make sure that we have enough time for our panelists for today. So hello, everyone. Welcome to this webinar. My name is Ramya Jawahar Kurekalu. I am the Telford Taylor Human Rights Teaching Fellow of Clinical Law with the Benjamin B. Friends Human Rights and Atrocity Prevention Clinic here at the Benjamin N. Cardozo School of Law. I want to welcome you to this event, which we've titled The Crisis in Ukraine, Understanding the Legal Lay of the Land, as a self-explanatory title. So we're very happy that you've come in. Before we begin, I'd like to take this time to acknowledge that Benjamin N. Cardozo Law School is situated on Lenape Island of Manhattan, in Lenapehoking, of the Lenape homeland. We pay respect to the Lenape peoples, past, present, and future, and their continuing presence in the homeland and throughout the Lenape diaspora. I'd also like to add, as a matter of housekeeping, we will be recording this webinar. If you have any questions during the period of the discussion, the conversation, please go ahead and put them in the Q&A feature at the bottom of your screen. You can do that throughout the discussion whenever a question strikes you, and our speakers will take the time to glance into that box, but also leave some time towards the end, perhaps, to address those questions. But please put in your questions into that box. This event is co-led by the Cardozo Law Institute in Holocaust and Human Rights, also known as CLEAR, and the Florsheimers Center. CLEAR, just for some context, is a global center for the study and teaching and promotion of human rights. The center is focused on strengthening laws, norms, and institutions to prevent mass atrocities, protect affected populations, and rebuild societies in the wake of atrocity crimes. Finally, I want to give a special thanks to our wonderful panelists here for joining us today. Thank you well in advance, because I know your conversation is going to be rich and informed. And I also want to thank CLEAR's program coordinator, Sam Scaller, for organizing this event and putting in a whole bunch of effort in making sure that this would come together quite quickly and in due time, as well as the Cardozo Events Office for all the support that they've provided. I'm going to go ahead and introduce our panelists. I want to concede to the fact that this introduction is definitely abridged, and that there is a wealth of history and experience here that I'm not going to be able to do justice to. So Professor Gabor and Professor Deborah Pearlstein. Professor Pearlstein is a professor of law and the co-director of the Florsheimer Center of Constitutional Democracy. Her work on the US Constitution, international law, and national security has appeared widely in law journals and the mainstream media, including some law journals, University of Pennsylvania Law Review, the University of Michigan Law Review, and in mainstream media, her opinions and reflections are present in The Atlantic, The New York Times, and others. Professor Pearlstein has repeatedly testified before Congress on topics ranging from war powers to the executive branch's oversight of those issues, In 2021, she was appointed the U.S. State Department as part of the U.S. State Department Advisory Committee on Historical Diplomatic Documentation, which is a 9-member board of historians, political scientists, and U.S. foreign relations law experts who help ensure the timely declassification and publication of government records surrounding major events with regard to U.S. foreign policy. Professor Gabor Rona worked previously as the International Legal Director of Human Rights First, where he advised Human Rights First programs on questions of international law and coordinated international human rights litigation. He also represented Human Rights First with governments, intergovernmental and non-governmental organizations, the media, and the public on matters of international human rights and international humanitarian law, or the law of armed conflict. Before Human Rights First, Professor Rona was a legal advisor in the legal division of the International Committee of the Red Cross in Geneva. At the ICRC, he focused on the application of international humanitarian and human rights law in the context of counterterrorism policies and practices. He also represented the ICRC in intergovernmental, non-governmental, and academic forums, and his articles are well available in both mainstream media as well as in academic journals, to name a few: Financial Times, the Fletcher Forum on World Affairs, and the Chicago Journal on International Law. He represented ICRC in connection with the establishment of international and other criminal tribunals, including the International Criminal Court. He also teaches international humanitarian law, international human rights law, and international criminal law at the International Institute of Human Rights in Strasbourg, France, the University Center for International Humanitarian Law in Geneva, Switzerland, Columbia Law School in New York, and of course, is a professor right here at Cardozo. A warm welcome to the both of you, and I will quickly and efficiently take my leave. Thank you so much for your time.
Thank you, Ramya, and thank you to Clear and to Sam for putting this together so quickly. I know there's been a great deal of interest among certainly our students here at Cardozo, and so we're happy to do what I view as, or what I hope to be sort of an explainer event. This is aimed at non-international law experts. You don't have to have taken a course in international law to understand what we're talking about, or to make sense of what's going on in the war and crisis in Ukraine that is unfolding as we speak. So what I think we're going to do, or what our plan is here, is that I'll say a few words by way of sort of setting the stage and giving you some basic information about what people mean when they say the international legal order and the UN Charter system, and why this particular conflict has given rise to such intense international response. Professor Rona will then talk about the law of war. What's often called the law of war is also called the Geneva Conventions and the law of armed conflict and international humanitarian law. We'll then say a few words about prospects for international criminal accountability, because I've gotten some questions about that. But really, mostly we want to be here to take your questions, which you can put, as Ramya mentioned, in the Q&A. And I've had students ask questions about constitutional law and nuclear weapons and so forth, and that's fine too. We'll do our best to answer all of them, although I should emphasize our information about, or my own information about what's going on and the facts on the ground currently in Ukraine. Obviously, things are evolving very quickly, and my information is no better than yours. And then I should finally say, while I do serve on a State Department advisory board, our work is unrelated to the topics we're going to talk about today. And in any event, I'm speaking purely in my personal and professorial capacity, not remotely on behalf of the US government. So, okay. So let me start by way of some basic terms, international law 101, as it were. Why has the global response to the Russian invasion of Ukraine been so uniformly condemnatory? Beyond the sort of obvious horror of conflict, we see conflicts happen and explode every day all over the world. Why is it that this one seems so profoundly threatening? I think part of the reason has to be understood as the perceived threat to the international legal order. And what is it that people mean when they say the international legal order? They mean a lot of different things, but principally they are talking about a system at its base that's created by the UN Charter, which is a multilateral treaty that was written and drafted and then ratified and entered into force after World War II. The United States was substantially responsible for helping to draft it. The United States has ratified the treaty under our own law, and indeed today there are 193 member states that are a party to the UN Charter Treaty. The UN system was created at base to do a lot of different things, but principally in response to the horrors of World War I and World War II, to deal with threats to international peace and security, to try to prevent a World War III, in essence. The principal legal rule, right, that the UN Charter sets out, the sort of prime directive for those of you who are Star Trek fans, is contained in UN Charter Article 2.4. So you might hear that provision talked about a lot. Article 2.4 of the UN Charter sets out the basic framework for rules governing the use of force. And in brief, it says, member states shall not threaten or use force against the political independence or territorial integrity of other member states, right? So it contains at its heart a prohibition against the use of force against the sovereign territory of other states. Now, there are lots of interesting legal questions that arise on what it means by force, and there are lots of interesting developing laws, especially when it comes to the use of cyber capabilities of different kinds. So plenty to talk about there. And this is why we have plenty of courses here at Cardozo on these topics. However, right, the easy case for what counts as a use of force in violation of Article 2 of the UN Charter is bombing or invading another country, right? So we are plainly in a use of force context here. And for reasons that I'm just about to explain, Russia's conduct here is clearly in violation of that basic Article 2.4 prohibition that prevents or that prohibits legally the use of force by one nation against another. Now, when I say for reasons I'll explain, there are several exceptions to the basic prohibition on the use of force. And most folks talk about two, or I think it's maybe easier to think about there being three exceptions, right? When is it ever okay for one state to use military force against another, right? Circumstance one is if the UN Security Council, which is an institution that was created by the UN Charter Treaty also, the UN Security Council authorizes the use of force, right? That obviously hasn't happened here. Circumstance two is if a state is using force in self-defense under Article 51 of the UN Charter. There's an exception for states to respond in individual or collective self-defense if they are attacked, right? So Ukraine, under these circumstances, would surely have a right and does have a right under Article 51 of the UN Charter to use force in response, in defense against the Russian attack on its territory. But there was no serious claim, not even by Russia in advance of the attack, that it was invoking Article 51 on its own behalf, right? Acting in self-defense. Although I'll come back to that in just a minute. And then the third exception is if the state against which the other state is using force consents, right? So for example, if NATO asks, Ukraine asks NATO or the Europeans or the United States to use force on its territory in as part of its defense against the Russian attack, right? That would be a classic instance of the territorial state, Ukraine, consenting to have other states using military force on its territory. That too is entirely acceptable under international law. And indeed, there is no international legal obstacle under those circumstances to the United States or Europe or NATO using force if Ukraine asks for their more active assistance. Now, the reason I said I wanted to come back to the absence of a Russian justification for this attack, which is true, and part of the reason you have seen such a fierce international response to the aggression here, is that in the lead up to the attack, very similar to the lead up to the attack, Russia's attack on Ukraine in 2014, you saw efforts by the Russian government to make the case that there was some, in essence, legal justification for its invasion. Russia's argument was, actually, they made a lot of different arguments. One of their arguments was that there was a genocide ongoing in the particular territories, particular regions of Ukraine that they were going in to defend. So a sort of claim of collective self-defense on behalf of what Russia calls these semi-autonomous territories. No one else in the world recognizes those territories as anything other than part of Ukraine. And indeed, there's no serious evidence that there was genocide or even significant violence ongoing in those territories. But Russia tried to tell that story for the purpose of supporting some sort of, or setting the predicate for some legal justification for its attack. The other reason you might have seen or might have heard Russia trying to explain that there's genocide going on the territory or the like is because many people argue that there is a fourth exception to the use of force against the territory of another state. And that exception is if there is a humanitarian crisis or genocide going on. So, for example, in the 1990s, you saw NATO intervene in Kosovo with enormous amounts of force to prevent a genocide carried out by the Serbians in Europe at that time. And it was clear at the time that NATO's action was in violation of the letter of the UN Charter terms, right? Humanitarian intervention is not considered on the sort of black letter understanding of the UN Charter, recognized legal exception to the use of force. On the other hand, there is a developing norm, and Kosovo may be the sort of foremost example, that suggests that this should be legally tolerated, legally permitted. This should be considered, as many would say, illegal, but nonetheless legitimate under circumstances of that nature. Russia, and there's lots more to say about the direction of the law on humanitarian intervention, but again, that's probably a whole course. Russia, in any event, was citing genocide and the need to move into these territories in Ukraine on behalf of what Russia called, ethnic Russians who were being discriminated against and persecuted and denied their rights to self-determination, in something like a Kosovo-like story for justification. Now here, the factual predicate was absent, but that's why you saw that kind of story or that kind of story being told by Russia in the lead up as a way of, as they have done in previous conflicts, trying to tell a story that this is not, in fact, such a direct violation of the UN Charter as it appears. So that's roughly where we stand. That's roughly where the sort of UN Charter stands. And it is a completely conventional and, I think, other than Russia, uncontroversial interpretation of the UN Charter to view what has happened here as a categorical violation of Article 2.4 of the UN Charter, right? A sort of classic case of a violation of Article 2.4 of the UN Charter, which leads, and this is the last thing I'll say by way of introduction and then turn it over to Professor Rona, which leads, I think, a lot of folks to ask and to write, so does international law matter here at all? Clearly, it didn't do anything to constrain Vladimir Putin in his current aggression against Ukraine. And again, we'll come back and talk about that use of that term aggression later. It's a legal term of art as well. And there, I think my response is a couple of fold, right? Number one, that's not exactly how law works, right? The United States and every other country in the world has plenty of domestic laws against murder, for example. They were completely ineffective at deterring Charles Manson from carrying out a grisly set of lengthy murders. We don't therefore conclude that the law of murder is not relevant to human behavior or ineffective on the basis of that singular example. The reason we think law matters in general, not just international law, is not that once there's a law, it is never violated. It is that if a law is violated, consequences follow, right? That's the idea. And that is exactly maybe surprisingly in some respects, what we are seeing here. We are seeing a clear violation of law and catastrophic consequences imposed by lots of parts of the international community in response. We can talk about sanctions, we can talk about criminal accountability prospects down the road, but we are seeing now, and I think clearly we'll continue to see, a host of consequences flow from this violation. So I think maybe for introductory purposes, I'll leave it there. And plenty more to say, but I want to stop talking sooner rather than later. So let me turn it over to Professor Rona.
Thanks so much, Deborah. And the very fact that we're kind of splitting this conversation between you and me, I just want to kind of pay homage to the notion that there are two rather large, different but related aspects of international law that we're talking about. And you're the one that's focusing, when you say on the UN Charter stuff, on the aspects of international law that deal with the preliminary question of when, if a state is ever permitted to use force in its international relations, when it is permitted to do so. Now we're going to kind of segue to a discussion about, well, once that happens, whether it happens legally or illegally, once that does happen, are there rules? And if so, what are the rules for how those hostilities are conducted? But one more thing before that occurred to me in connection with the UN Charter related issues. I have heard quite a bit over the course of years from the Kremlin and from Putin himself, claiming the hypocrisy of the West, and particularly the United States, which has a pretty well-established history of using force in international relations, not in self-defense, not with Security Council authorization, not with the consent of the country in question, situations of interfering with liberation movements, overthrowing governments, and the sort. And I think his claims and others' claims about the hypocrisy of the US may be valid, but I think it's also important to point out that there's one very significant difference between what's going on in Ukraine now and maybe the whole history of alleged and real US violations of the UN Charter. And I'm not aware of any circumstances in which US has used force in its international relations for the avowed and effective purpose of destroying another country. I'm not aware of circumstances in which the US has used force for the purpose of annexing a sovereign state. And Putin has made it quite clear that he believes that Ukraine is not a real country, and his ambition and his intention is to in effect either rebuild what was the Soviet Union or make Ukraine part of Russia. That is a very different type and degree of violation of the UN Charter than we typically see, I think, these days. And I'm guessing that difference is part of the reason why there has been such a loud and strong international outcry. Going on to the issues concerning the conduct itself of the hostilities, it has, I think, long been a popular, though incorrect notion, maybe made popular in the first place by Cicero of all people, that in war there is no law. Well, Cicero was wrong then, he's wrong now, and it has been well established long before there were states on planet Earth that there were rules for the conduct of war. This was not a human rights oriented notion, it was a self-preservation notion. And it was, I think, made more clear in our modern world, even, I guess it was 400 years ago, by Rousseau in The Social Contract, and I want to get the terminology right, so I'm going to quote, that the only legitimate object in war is to reduce the enemy's capacity to wage war. In other words, not annihilation, not conquest, just to stop the enemy from being able to make war against you. And in pursuance of that goal, modern international law, namely the Geneva Conventions, have given rise to a bunch of rules that deal with and expound upon a very few and fundamental principles of the law of armed conflict. One of them is the principle of necessity, and that is you can only target things that make an effective contribution to military action and that confer a definite military advantage if you attack them or negate them or destroy them. Another is the principle of distinction, that combatants have to distinguish between enemy combatants and civilians. They have to distinguish between military objectives and civilian objects, and they can only target enemy combatants and military objectives. They cannot target civilians and civilian objects. A corollary of that is an entire infrastructure that has been created under the Geneva Conventions for what happens when people are captured. Well, if they're captured and they're combatants, then they're entitled to special protections and status as prisoners of war. If, on the other hand, it is civilians who are captured, they too are entitled to a different but very explicit set of rights that are obligations on the detaining authority under the Geneva Conventions. Now, all that said, if a civilian should happen to take part in hostilities, they lose their protection as civilians. And it is not uncommon that civilians do take part in hostilities. In that case, they're no longer exempt from being targeted. If captured, they're not entitled to prisoner of war status and protections because they are not combatants. But they are nonetheless entitled to humane treatment, as are prisoners of war. Now, we haven't heard a lot about captures in this armed conflict yet. And it may very well be that we don't, but it may also well be that we do in ensuing days and weeks. And in that event, the rules of the law of armed conflict and the Geneva Conventions concerning the protection of civilians and combatants who are taken off the battlefield, who are detained, become increasingly important. But right now, the focus is on conduct of hostilities. What are the means of combat that are permissible? What are the methods of combat that are permissible? In relationship to that, it is also critical that those who are engaged in hostilities not only distinguish between combatants and civilians, between military objectives and civilian objects, but that in anticipation of the very real probability that even if you are targeting only a military objective, civilians can be harmed. And the rules of international law do not prohibit all civilian harm, but they do require that any attack, even on a legitimate military objective, not be conducted if the civilian harm consequences will be disproportionate to the military advantage gained. Now, that means that combatants have yet another obligation, not only to distinguish between combatants and civilians, but to make sure that their attacks satisfy this rule of proportionality. They are also responsible for taking precautions to the extent that they're available to assure the minimization of civilian harm. These rules, distinction, proportionality, precaution, I think we've already seen a massive amount of evidence for conclusions that these principles have been violated. And as you said, Deborah, we will talk a little bit further about potential accountability mechanisms later on, but it is extremely important that the international community, in addition to noting its opposition and its pique concerning this Russian intervention, do everything under the sun that is feasible to catalog evidence of these violations for later accountability measures to be implemented and applied. Finally, I want to say just a couple of other things about these potential violations. We've heard that that Russia has been bombing cities. We've, I think, seen the examples of the bombing of the center of the city in Kharkiv. And the question arises as to war crimes that may be being committed in this conflict. How far up the chain of command does responsibility go? For that purpose, it's not enough to just look at the events of this armed conflict. So, for example, I think we know that in Chechnya and in Syria, it was a Russian tactic to bomb the center of a city, to target civilians for the purpose of, I would suspect, and certainly causing terror within the civilian population. But it also had a strategic effect, a strategic purpose. And that is, if you bomb the center of the city in violation of the Geneva Conventions, you may well cause the forces that are protecting that city on its periphery to have to withdraw into the city, and thereby make the invasion of that city easier for invading forces. We've seen this, as I said, in Chechnya. We've seen it in Syria. We're seeing it in Ukraine now. And so I think it will be just as important to look at patterns and practice of behavior of Russian forces, not so much for the determination of whether or not war crimes are being committed in this conflict, but how high up the chain of command responsibility for those war crimes can and should go.
Thanks, Gabor. So let me say two words and encourage and remind everyone to put questions in the Q&A, because we want to be responsive to what you're interested in about this scandal, the conflict. And if we've talked about it yet, great. If not, be sure to remind us and let us know. On the question of criminal accountability, because the rules that Gabor just described, right, that is the law of war. It's set forth in a variety of different places and a variety of different legal instruments. But the consequences of its violation is that if you violate those rules, you are committing a war crime. Now, what does that mean, and what happens or what could happen to the people who are in the Russian military who are committing them, for that matter, if there are any war crimes being committed on the Ukrainian side, up the Russian chain of command, the command level? How worried are they, should they be, about the prospects for criminal accountability down the road? There are really three places, jurisdictional places, where criminal accountability in a conflict after a conflict might take place, right? Number one, and I think most likely, and what we've seen happen most commonly with respect to the war crimes committed in Syria, is the assertion of domestic criminal jurisdiction by other countries with jurisdiction. Because war crimes, violations of key provisions of the Geneva Conventions, are considered universal jurisdiction offenses, right? The usual rules about when a country can assert its jurisdiction to deal with either to apply the law, right, its legislative jurisdiction, or personal jurisdiction, which you may know from civil procedure, right, in a sort of judicial sense, or any other form of jurisdiction, right? Universal jurisdiction crimes mean they don't have to have happened in the territory of the prosecuting country. They don't have to have involved nationals of the prosecuting country. They don't have to have had any sort of direct impact or contact with the prosecuting country. War crimes are universal jurisdiction offenses in the sense that the law understands they are crimes against the whole world and should be susceptible to criminal accountability in any country that has an applicable statute. Germany, lots of European countries have applicable universal jurisdiction statutes, criminal laws on their own books that would apply here. They've used them with increasing success when they're able to gain custody, as they have, over various Syrian officials who have fled or even just stepped outside of the borders of Syria since the conflict. And those prosecutions, I think, are the most likely category we will see, or at least the soonest. Is that to say we will see them anytime soon? No, I don't think we will see them anytime soon. But it is to say that if I were the lawyer of a Russian commander, or maybe more importantly, of a Russian foot soldier who's contemplating whether to surrender or contemplating the legality or wisdom of what they are being asked to do in Ukraine, I would worry intensely about the prospect of future criminal prosecution by virtually any state of the world outside Russia, even if the Russian regime survives. And that deterrent incentive, right, is a significant one on the ground, even in real time. To the extent they're aware of it. And that's why you see major sort of information campaigns on social media and elsewhere by Ukraine, which is extremely effective at this kind of information warfare, to try to emphasize, to try to both record and emphasize the seriousness of the conduct here. There are two other criminal prospects. One is the ICC, the International Criminal Court. Neither Russia nor Ukraine are parties to the treaty creating the International Criminal Court. That is a standing international criminal court that was born very recently in international legal terms, right? It's a baby court still. There have been a handful, by which I mean, I think still, Gabor, less than 5 successful concluded criminal prosecutions by the ICC arising out of conflicts in different parts of the world. The ICC prosecutor has announced that he was beginning a preliminary investigation into allegations of war crimes already in the context of the Ukraine conflict. But both the United States and Russia have taken the position that even though the ICC on paper should have jurisdiction over certain kinds of offenses for a variety of reasons we can talk about if you want to talk about the ICC in detail, it would be inappropriate to exercise jurisdiction here. So the politics surrounding the ICC's existence becomes a really significant issue. The third prospect, which I think is least likely to evolve, but not out of the question, is that there would be some sort of ad hoc tribunal created. So after the conflict in Yugoslavia surrounding, and in Kosovo that I mentioned earlier, after the genocide in Rwanda also in the 1990s, the UN Security Council created special courts under its authority that then went on to, in a very effective way in key respects, pursue and obtain criminal accountability for not only low-level participants, but relatively senior military figures in those conflicts and indeed civilian figures in those conflicts who perpetrated war crimes. The reason I say it's less likely here, although not out of the question, is because obviously Russia holds a veto on the UN Security Council. The UN Security Council is unlikely anytime in the near term to create such a tribunal. But there has already been a discussion that the UN General Assembly, which generally does not have that kind of legal authority, might, under extraordinary circumstances, exercise it here. Now, that would be an unprecedented move. It would be a legally controversial one, but not legally out of the question, and so it raises a bunch of interesting questions that might be pursued again down the road. I think I want to stop there and maybe Gabor, maybe one or two other words, but we have some Q&As in the chat, and I want to encourage folks to continue to do that so we can get to those.
The only things I'd want to add to what I think is a very thorough but concise reflection on the potential for criminal accountability concerns the aspects of the Geneva Conventions in which criminal accountability comes up. The Geneva Conventions talk about what are called grave breaches, the grave breaches regime. Not all war crimes are grave breaches. A state can decide whatever it wants to in its national law that would constitute war crimes. But what the Geneva Convention says that there are certain breaches of the law of war that are so serious, that are so grave, that they are the ones that, as you said, give rise to not only the potential for the exercise of your universal jurisdiction, but I think it's important to emphasize the obligation to exercise universal jurisdiction. When states become parties to the Geneva Convention, and every state on planet Earth is a party to the Geneva Conventions, one of the things that they commit to is to search for anyone that is suspected of having committed grave breaches that may be on their territory, and when found, either prosecute them or extradite them for prosecution to someplace else. This is a mandatory regime, and it reflects the fact that there are certain violations of the laws of war that are more serious than others, and that states will have an obligation to prosecute regardless of whether or not the kind of ordinary indicia of jurisdiction, like it happened on my territory, or the person who did it, or the victim was my national, regardless of whether or not those elements are present. Then as to the ICC, there's been a lot of, I think, perhaps confusion and some question about exactly what crimes the ICC could take jurisdiction over. And in accordance with its statute, the ICC generally has jurisdiction over war crimes, crimes against humanity, genocide, and the crime of aggression, namely what, as you said, what is this term of art, which is the violation that states commit when they are out of compliance with Article 2.4 of the UN Charter, waging aggressive war. But as it happens, the states that negotiated the International Criminal Court Treaty have decided in their infinite wisdom that while the ICC can exercise jurisdiction over war crimes, crimes against humanity, and genocide that occur either on a state that is a party to the treaty or by a national that is party to a treaty, that the crime of aggression could only be prosecuted if the state of the individual who is suspected is a party to the treaty, or if the Security Council authorizes the prosecution, neither of which is the case here. So Ukraine has authorized the ICC to take jurisdiction over cases that arise on its territory, even though even though Ukraine is not a party to the ICC treaty, it has recognized the jurisdiction of the court. But that would not include jurisdiction over the crime of aggression. So the ICC, I think, would have good standing to prosecute war crimes that occur on the territory of Ukraine, crimes against humanity, but not the crime of aggression, unfortunately.
It's an interesting moment, actually, on the ICC point. I agree with everything you just said. That if the Ukrainians, recognize solicit the jurisdiction of the court, it can certainly assert authority. But the United States has carved out a very aggressive position that the ICC should not be able to, and indeed legally cannot, assert jurisdiction over individuals who are members of states who aren't party to the ICC. Now, this is a very interesting moment. That was a position taken during the Trump administration. It's a very interesting moment to see whether the US government, because this tends to have bipartisan interest in the ICC when it's a country we don't like, whether this is a moment where the US position on the ICC might change. Let me actually, Gabor, while you're talking though, I've been looking, there's some questions that are starting to come in, and that's great. So let me just start with one. The news videos are filled with images of ordinary people being armed. Does this imply turning non-combatants into vulnerable targets? What about the ubiquitous images of ragtime bottles of gas? So do you want to take what the status is of these ordinary Ukrainians who are arming themselves, whether they can be targeted, and what their situation is? And I'll talk a little bit about weapons issues.
Right. The simple answer is if a civilian takes up arms, then they lose their protection as civilians. They do become targetable. If they are captured, they are not entitled to prisoner of war status and protections. These things have different degrees of importance in international law than in domestic law. It just so happens that the international law of armed conflict doesn't have a problem with civilians taking up arms. It's not a war crime. However, it is a domestic law crime, I think in all places that I'm aware of, for people to commit acts of assault and murder. Now, they may or may not get prosecuted under these circumstances, but if civilians do take up arms, number one, they lose their protection as civilian status, at least while they are participating in hostilities. And depending on kind of nuances of how the law of war is interpreted, they may lose their protection permanently, especially if they participate in hostilities on a continuous rather than a one-time basis. But while they lose their civilian protection from attack, they do not gain any of the protections that combatants have, which most importantly is the entitlement to prisoner of war status if they are captured, but also for domestic law purposes, combatants have what's called a combat immunity. If you are a member of the armed forces of a state in an armed conflict and you are engaged in acts of hostility, you are immune from the operation of domestic criminal law for acts that you commit, unless of course they're war crimes, torture, rape, etc. But if all you're doing is committing, legitimate acts of war, you have what's called combat immunity from criminal prosecution if you are a so-called lawful combatant. Civilians who participate in hostilities don't get that immunity. That's a big difference.
So on the question of, so I'm not 100% sure which images you're looking at with rag prime bottles of gas, but the images I've seen, right? I've seen a lot of stories about different kinds of weapons. So let me just mention, the sort of traditional Molotov cocktails. There are much more advanced kinds of weapons that we hear about on the Russian side, cluster munitions of various kinds. I've seen a lot of writing about thermobaric weapons of different kinds. Without going into too much of the technical detail of how each of these weapons work, let me say just a few things. Number one, none of the things that I just mentioned are categorically prohibited as a matter of law. Law does absolutely prohibit certain kinds of weapons in war. The two most important are certain kinds of chemical weapons, although not including traditional Molotov cocktail, and certain kinds of, and indeed all kinds of biological weapons. Those are governed by separate treaties. There's a biological weapons convention, which is a separate treaty. There's a chemical weapons convention, which is a separate treaty. There are a series of other treaties, which folks tend to call Hague Law, based on one of the original treaties, that govern means and methods of warfare, right? So what kinds of weapons can you use and what happens to you if you use those weapons, and what are the consequences that follow? The weapons that we've been talking about just now, right, are not prohibited by any of those treaties. They do, however, particularly the cluster munitions and the thermobaric weapons, that was one of the large explosions we saw, right? These are weapons that operate as a combination of gas and air that explode outside the chamber of the weapon and can cause these huge fireballs and other sort of catastrophic explosions. The reason that these weapons can be so worrisome is because of the likelihood and the very high risk that they will violate or that they won't be used in a way consistent with the principle of distinction. So if you think about, drone strikes, but even standard bombing techniques or bombing techniques against clear military targets, right? With military as advanced as Russia, they can put a weapon pretty much where they want it to go if they want to. But these weapons, cluster munitions, thermobaric weapons, and others, have a much can have a much wider range of dispersal. That's part of why they're used against cities. And if you're using them in a place where, even if you're aiming at a military target, if it's right next to civilian targets or the like, the risk that it will be used, and indeed by Russia often is used in a way that violates these other rules of the law of war and our war crimes, is very high. It's what we saw in Syria. It appears to be what we're seeing here. And so that's some of the primary worry about those, in addition to the sort of horrific humanitarian consequences of certain kinds of those weapons.
Yep.
The whole situation is horrifying, but there's some weapons that are even more horrifying than others, and these are among them.
Deborah, here's another question that I think is for you. Russia seems to be making the argument that Ukraine is not a state, the question says. If that's true, is that outside of the scope of the prohibitions that you were talking about under the UN Charter? Does that have anything to do with the exceptions that you mentioned to the permissibility of use of force? Does it turn an international armed conflict more into a civil war where the UN Charter has nothing to say about the state's use of force in the first place?
So that is so interesting. I don't see that question at all, but I believe you that it was posed. Oh,
It's
wait,
there.
maybe, yeah, not a state. I got it. Sorry. So is there an argument that Ukraine is not a state? So Russia seems to make the argument Ukraine is not a state, right? Russia is alone in making that argument. Can a powerful state turn a conventional interstate conflict into something more like a civil war? Right. So you could take this question as well as I can. The short answer is no, not readily. The Ukraine is a member state of the United Nations, right? So just as when the US invaded Afghanistan in 2001, while the then Bush administration took the position that the government of Afghanistan, the then Taliban government of Afghanistan, was legitimate, it was illegitimate, that Afghanistan was a failed state, right? One of the central sort of bargains, both of the UN Charter, but of the Geneva Conventions as well, is that if you are a member state with UN recognition, you are a state for the purposes of the applicability of this law, whatever the enemy state says. And the same sort of principle is at work in the modern Geneva Conventions, right? So whether or not, and the Geneva Conventions are explicit about this, one state declares war against another, whether or not one state says, likes the government or not, because typically they don't, right? These are state parties, and the law here applies as a matter of default. So could this ever become something like a civil war? Yes. If the government of Ukraine is what is sometimes informally called decapitated, but if the government of Ukraine falls, right, to the Russians, and the Russians seize control of Ukraine, or seize effective control of the government, then there will be a Russian-controlled state in Ukraine, and presumably an ongoing insurgency by Ukrainian forces, and that will be a civil war, much like we saw unfold in Afghanistan over 20 years. It is entirely possible, and some folks I read would say likely, that is the situation we are headed for here. Obviously, I hope not, but that is possible. We're not there yet. I don't know, Gebor, if you want to add anything to that.
No, I think that sums that up perfectly. I did want to acknowledge that there was another question related to what happens when civilians are captured. So the questioner cites correctly that it's the Fourth Geneva Convention that protects civilians on capture. The Third Geneva Convention is about combatants and prisoner of war status. But under the Fourth Geneva Convention, if a civilian is captured, they have certain rights. The question was, well, what if that civilian has been directly participating in hostilities? Yes, they lose their civilian protection from targeting, but then have they also lost their civilian protections that are otherwise applicable to them under the Fourth Geneva Convention if they're taken into custody? And the answer is no, they do not lose Fourth Geneva protections. Civilians who participate in hostilities, even if they don't have a privilege to participate in hostilities the way combatants do, if they're taken into custody, they're entitled to the protections under the Fourth Geneva Convention. Maybe one of the reasons this is an issue is because the US experience in connection with Guantanamo detention, early on, the US took the position that either the Geneva Conventions don't apply or that various aspects of the Geneva Conventions, like the POW Convention, don't protect individuals who are fighting against the US because they were not lawful combatants. The Geneva Conventions are written in such a way as to make it absolutely certain that no one falls through the cracks. And for that reason, there's a definition of what constitutes a combatant, but there's no definition of what constitutes a civilian. Rather, the Fourth Geneva Convention says everyone who's not protected by one of the other conventions is protected by the Fourth Geneva Convention if they're captured in an international armed conflict. And what that means is that since a civilian is never going to be protected by the Third Geneva Convention, they will continue to be protected by the Fourth Convention. Nobody falls through the cracks. There's another question. Deborah, I'm curious about what your impression is of the prospect that's been under discussion about a no-fly zone being established over Ukraine. And maybe that's not a strictly legal question, but has other ramifications as well. But there you go.
Yeah, I'm going to take it as mostly a legal question. So what's a no-fly zone? What it means and how does that work? So a no-fly zone is not a term of legal art. It's a popular term, right, that's used, and I've seen discussions of it in the media already in the context of this conflict. The notion that, and the suggestion is that NATO or the United States or someone in Europe, right, should intervene militarily in the conflict in Ukraine to enforce a prohibition against air traffic in Ukraine. This is a very specific and maybe obfuscatory way of saying there should be military intervention in the conflict by the United States, NATO, or another European country, right? All a no-fly zone means is that another state or military authority will engage and shoot down planes or engage planes, presumably in this case, Russian planes, that are flying in the absence of a no-fly zone, right? It's a military and strategic term. It is not a legal term. If another state engages, right? And here, and this may be, I know we're running out of time already, which is amazing. But I guess let me just say a few things about prospects for either a no-fly zone or what tends to be called a no-fly zone. I think people use it politically as a way of trying to talk about limited forms of intervention, but legally, anything like a no-fly zone is exactly the same as anything like bombing Russian tanks or any other military intervention. It would render the state who's providing that military intervention a party to the conflict. That state, let's just say the United States for now, right? I don't think this is at all likely to happen, at least not anytime soon, would become a party to the conflict. They too, right, the participants on behalf of the United States, presumably the US military, would become combatants with both the privileges and burdens associated with that Gabor set forth. They would be vulnerable to war crimes prosecution in just the same way that Russian troops would be vulnerable to war crimes prosecutions. They would be bound by all the same requirements that we have laid out here as otherwise binding. So that's what that would mean. Now, why do I think that's not likely? Even though we are in a situation, for reasons that I said at the outset, where there is no international legal obstacle to external intervention at this point if Ukraine requests assistance, right? Actual military intervention. For the United States, there are two mammoth hurdles. Hurdle one is the availability of domestic US legal authority that would authorize that kind of military engagement, right? The existence of the NATO treaty itself is not sufficient, is indeed not authorization of any kind, even if the NATO parties agree to invoke Article 5 that you might have heard of, that still doesn't count as domestic legal authorization. Domestic legal authorization would need to come from an act of Congress or a constitutional justification by the president. I think those will be hard to come by in a conflict like this, and we could talk about that more in a constitutional setting. I'll be talking about it in my constitutional law class with my students on Thursday. But the other reason, in addition to concerns by the US population about engagement in another war, is the risk of escalation. Putin has already mentioned nuclear weapons on several occasions. He didn't need to mention them for anybody to worry about that. And that is a risk that is in the back of everyone's mind, unquestionably, and not so far in the back of everyone's mind. Putin has said historically on many occasions, if there is a third world war, there will be nuclear weapons used. There are a lot of scenarios in which nuclear officials, nuclear policy experts have imagined a conflict in Ukraine giving rise to that kind of a risk. And reality, and that is something that I think continues to act non-legally as a significant limiting factor in thinking about the prospects for additional conventional engagement. Does that mean it won't happen? No, I don't know what will happen. That's above my pay grade, but I am confident that that is part of the calculation. Maybe we should take, I know we're a few minutes late, but maybe Gabor, you want to take one more question and then we'll call it quits.
So there was a question about China's stance or lack thereof. I think I would have to treat that more as more of a political question than a legal question. Although I have to say from whether it's a legal perspective or real politics perspective, I think we should be grateful that China has abstained and not sided with Russia in the Security Council. But anything more than that, I think I see. Ramya, would you like to address that question?
Dear caught in headlights.
Oh,
it's okay. You don't have to.
No,
not at all. I welcome the question.
I saw in the comments it said.
No, it's just a technical comment. So
okay.
no, Gabor, I do not want to answer that question. Thank you.
Okay, that's fine. Well, other than the fact that I think we should be, relieved that that China has abstained rather than sided with Russia in the Security Council. I think from a political perspective, China has some opposing interests to weigh here. They may be inclined to want to be sympathetic to the Russian case when they're thinking about Taiwan, but they may be concerned in connection with their relationship with Hong Kong. And I think that the question of how things will play out with China may in part depend on how much support the international community gives to the notion that that China has put forth that it could conceivably act as a mediator in this conflict. I would love to see support for that notion grow. I think it would help, help channel China to be focused in the right direction, and I think help keep China from moving more sympathetically toward the Russian camp on the issues in connection with Ukraine. But as I said, I think these are political considerations and not legalistic ones.
I know we have other questions that we didn't have a chance to get to, and I regret that. But given that our Zoom will expire in the near term, and also that we've taken quite a bit of your time already, I think we should conclude our discussion here. There's obviously lots more to say. I wish I had happier things to say, but I'm grateful for all of your interest, and especially grateful for my co-panelist and for Sam and Ramya for putting this together. I'm happy to have been a part of it. So thank you all.
Me too. Thank you, everybody. There's one thing I do want to say in conclusion. There's been a lot of hand-wringing about the future of these international law principles and rules. It's entirely possible that, yes, we are at an inflection point. It's just as possible that the global reaction to this crisis will help to shore up international prohibitions against state use of force in ways that needed to be shorn up and that didn't exist before. Of course, it's also just as possible that things will go south from here rather than north. But the extent to which the international community has spoken with one voice against China, the Russian aggression here, I think bodes well for the future of this area of law that many of us believe is the cornerstone to the maintenance of international peace and security. So I'm not entirely pessimistic. As horrible as the consequences are going to be in the near term in Ukraine, the consequences may turn out to be okay for the persistence of international law. Thank you, everybody.
That's a much better way to end.
Thank you. Okay.
All right. Thank you so much to everyone on, of course, our panel, as well as everyone who attended. We're really glad we've had such a great audience. Also, I want to apologize for those who submitted questions and we couldn't get to them. These things are limited by time and scale. But I'm sure the conversations will be ongoing. Please look out for both these scholars, perhaps their work, and maybe somewhere in mainstream media, their reflections will expand on some of the things that they've said here. But on behalf of both the centers that have led this event, thank you so much, and have a good rest of the evening and rest of the week. Thanks.